Nyo until 12 midnight. Yes, sa Jollibee. You can do. Ay, ibang usapan yun. Binigyan na kayo ng dinner, gusto pa niyong bayaran ko. Ano ba naman yan? Anong klaseng labanan yan? You are so unfair. Yan daw rains, ha? Blessing daw yan. Maganda yan. That's a good sign for all of us, di ba? Kaya lang, unahan ko na to. Mabasa ko eh. Unahan ng biogesic. Yung atasi case ko, parang butika to eh. Merong biogesic, merong atapulgite, merong... Siyempre, importante yun eh. Baka abutin ka dyan eh. Mahirap na, di ba? So, where are we now? We are here. You have to be responsive to the question. My question is, where are we now? We are here. Ay, talaga kayo, ha? Number one rule in taking the bar examinations, be responsive to the question. Di ba? Okay. The Bill of Rights. Let me see. Tingnan natin. Fundamentals. Hoy, fundamentals. What is Section 23 of the Bill of Rights? Ala, sige, nagtingin pa. Walang Section 23, hanggang 22 lang yan. Ay, nako talaga rin naman, oh. Bukas kagad siya ng libro niya, oh. Kayo talaga, oh. Hanggang 22 sections lang yung Bill of Rights. You know that. You should know that one, di ba? The Bill of Rights is in your political law. Remember, if you go back to political law, what are the three important parts of a written constitution? Constitution of government, Constitution of liberty, Constitution of sovereignty. With respect to the second, Constitution of liberty, essentially we refer to the Bill of Rights. That is your Constitution of liberty. Without the Bill of Rights, the state can practically do anything, and you cannot complain. For example, without the Bill of Rights, without Section 9. Oy, salamat ha. Without Section 9, your private property may be taken away by the state at any time of day or night. And can you complain? You cannot. But since there is Section 9, it says there that private property may not be taken for public use without just compensation. The state cannot just do that. If it wants to take private property, it must pay just compensation. And there must be due process. Hindi po pwede yung basta, kailangan ko na yan, kukunin ko yan. Because the taking, remember, the property taken must be converted to public use. So the owner of the property must be given that opportunity to challenge the expropriation. Is that really for public use or purpose? O baka naman for private use yan? Or baka naman whimsical or capricious? So there you are. In that sense, the Section 9 becomes a limitation on the power of eminent domain of the state. Without Section 2, what right is that? The right against unreasonable searches and seizures. You can be searched, you can be arrested, your house can be searched at any time of day and night, and you cannot complain. But there is a guarantee under Section 2. Because of that, the state cannot just do that. There must be a search warrant or warrant of arrest. Di ba? So in that sense, as you can see, the Bill of Rights really constitutes a limitation on the powers of government. You have to view it in that context. That's why sometimes our Constitution has been referred to as essentially a limitation on the powers of government. It is because of the Bill of Rights. Okay? Take note of that. Do not forget the fundamentals. Now, as I said, there are only 22 sections in the Bill of Rights. Huwag niyong dagdagan yan, ha? Ang hilig magdagdag nito. And actually, if you go over Section 9, strictly speaking, is that the right? Strictly speaking, is that the right? Section 9? It says there, private property may not be taken for public use without just compensation. That is more a limitation on the power of eminent domain of the state. So strictly speaking, it is not really a right. It is a limitation on the power of eminent domain of the state, so that the state may not take away private property and convert that to public use without just compensation. So you can take it out of the Bill of Rights. So 21 na lang yan. Di ba? A lot easier to remember. 21 sections na lang yan. Now, why don't you look at Section 15? What does it state there? The privilege of the writ of habeas corpus may not be suspended except in case of invasion or rebellion when the public safety requires it. Hindi ba na-encounter na natin yan? Saan? Section 18 of Article 7. So you can take it out of the Bill of Rights. So ilan na lang yan? O 20 na lang, di ba? Di ganun kasimple, tapos na. O ano pa? That's the Bill of Rights, di ba? Okay. It's becoming interesting now, ha? So actually, strictly speaking, we are only dealing with 20 sections. Di ba? That's easier to think. 20 sections lang yan. Tapos, iiyak ka dyan sa 20 sections na yan. Oh, that's unreasonable on your part. Di ba? Now, did you analyze the 22 sections? Mayroon bang binabanggit na right to appeal? Hoy! Wala! That is the reason why appeal is not a constitutional right. It is not found in the Bill of Rights. It is merely statutory. So that if there is no law that grants you the right to appeal, you cannot appeal. So you have to look at it in that context. It's not found there in the Bill of Rights, the right to appeal. Kaya nga lagi ko inuulit yan, remember that appeal is not a constitutional right. It is not found in the Bill of Rights. It is not found in the Constitution. It is merely statutory, so that if there is no law that grants you the right to appeal, you cannot appeal. Okay? Remember, Now, again, why don't you analyze the 22 sections of the Bill of Rights? Meron bang binabanggit siya na right to privacy? Aber nga, abi, isa-isahin nyo yung 22 sections. Section 3 yan. But Section 3 speaks of privacy of communication and correspondence. Obviously, that is a limited concept of privacy right. Privacy of communication and correspondence, hindi ba? So, meron ba talagang right to privacy? Basta, meron. Now, that was settled by the Supreme Court in Oakley versus Torres. Sabi ng Supreme Court, meron talaga yan. Because the essence of privacy is the right to be let alone. That is the essence of privacy. The right to be let alone. Actually, tayong mga Pinoy, mahilig na tayong mag-invoke niyan. Consciously or unconsciously. Yung right to privacy. Mahilig tayong mag-invoke niyan. Consciously or unconsciously. Ano yun? Hindi ba it is a favorite expression among Pinoys, wag mo akong pakialaman. Whenever you utter those words, you are invoking your right to privacy, because the right to privacy, the essence of privacy is the right to be let alone. Hindi ba? Uy, it's as simple as that. Now, sabi nga ng Supreme Court in Oakley versus Torres, the essence of privacy is the right to be let alone. That is the essence of privacy. In the 1965 case of Griswold versus Connecticut, the U.S. Supreme Court gave more substance to the right to privacy when it ruled that the right has a constitutional foundation. It has a constitutional foundation. It held that there is a right to privacy which can be found within the penumbras of the First, the Third, the Fourth, the Fifth, and Ninth Amendments. In the 1968 case of Murphy versus Mutok, sabi ng Supreme Court, take note of this, in the 1968 case of Murphy versus Mutok, we held, or rather, we adopted the Griswold versus Connecticut ruling that there is a constitutional right to privacy. That's a very significant statement. In the 1968 case of Murphy versus Mutok, we adopted the Griswold versus Connecticut ruling that there is a constitutional right to privacy. And then the court went further. Sabi ng Supreme Court, indeed, if we extend our judicial gaze, we will find that the right to privacy is recognized and enshrined in several provisions of our Constitution. That right to privacy is recognized and enshrined in several provisions of our Constitution. It is expressly recognized in Section 3, Paragraph 1 of the Bill of Rights. Right to privacy of communication. But aside from that, other facets of the right to privacy are protected in various provisions of the Bill of Rights, like those in Section 1. The right to due process, it has a strong element of privacy right there. You may not be deprived of life, liberty, or property without due process of law. Section 2, the right against unreasonable searches and seizures. Again, there is a strong element of privacy right there because the provision says the right of a people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable. It has a strong element of privacy right there in Section 2. What else? Section 6. Ano ba yung Section 6? The right to liberty of abode, liberty of changing the same abode, the right to travel. Gusto mo ba na every time you travel, minomonitor ng gobyerno yung movements mo kung saan ka pupunta? Of course you don't want that. The right to be let alone. It is an element of privacy right there. A strong element of privacy right there. Section 8, freedom of association. It has an element of privacy right there. Why? Because remember that freedom of association includes freedom not to associate. Can you be compelled to join an organization if you don't feel like joining it? Hindi pwede. That is part of your freedom of association. Freedom of association includes freedom not to associate. Section 17, the right against self-incrimination. Can you be compelled to testify against yourself? Hindi pwede. Again, it has an element of privacy right there. So as you can see, sabi nga ng Supreme Court, this right to privacy, this is recognized and enshrined in several provisions of our Constitution. Not only in Section 3. Section 3 speaks of a limited right to privacy of communication and correspondence. Other facets of the right to privacy are found in other provisions of the Bill of Rights, like those in Section 1, Section 2, Section 6, Section 8, Section 17. Because after all, what is the essence of the right of privacy? The right to be let alone. Be guided by that. Now, the Supreme Court did not stop at that. Sabi ng Supreme Court, aside from the provisions in the Constitution, there are even zones of privacy recognized and protected in our laws. Like the Civil Code. If you will recall, your chapter on human relations in the Civil Code, every person shall respect the dignity, personality, privacy, and peace of mind of his neighbors and other persons. and punishes as actionable torts several acts by a person of meddling and prying into the privacy of another. Do you still remember that one? That is an actionable tort in your chapter on human relations in civil law. Hindi ba yung meddling and prying into the privacy of another? Oy, ang hilig ng mga ladies dyan. Meddling and prying into the privacy of another. Ichichismis ka pa. Diba? Oy, that is an actionable tort. You may be held liable for damages there. Chapter on human relations. It also holds, the civil code also holds a public officer or employee or any private individual liable for damages for any violation of the rights and liberties of another person. The civil code recognizes the privacy of letters and other private communications. Kaya nga, hindi ba pwede ba yung your letter in the mail, pwede bang buksan yan ng another? Ay, hindi pwede. That is an actionable tort. Now, what about the revised penal code? It makes a crime a violation of secrets by an officer. You know that very well. Very well. The revelation of trade and industrial secrets. And of course, trespass to dwelling, that is a felony, criminal felony. Then invasion of privacy is an offense in special laws, like Republic Act 4200. Ano yung Republic Act 4200? Ay, nako, some of you may be guilty of that. You may be taping my lecture. I did not consent to that. Neither did I know that one. Hoy, merong namutla dyan ah. Ay, nako, sige kayo ha. Ano pa? Secrecy of Bank Deposits Act, the Intellectual Property Code. Then the rules of court on privileged communication likewise recognize the privacy of certain information. Like those in Section 24, Rule 130, Paragraph C. Ano yun? Ha? Oy! Husband and wife relations, di ba privileged communication? Priest, confessant, doctor, patient, lawyer, client. Hindi ba privileged communication yon? So as you can see, not only are they enshrined in the Bill of Rights, there are even zones of privacy recognized and protected in our laws, like those in the Civil Code, like those in the Revised Penal Code, like those in the Special Penal Laws, like those even in the Rules of Court on Privileged Communication. So, settled yan ha, mayroon talagang right to privacy. Because the essence of privacy, after all, is the right to be let alone. Okay? So, it is not only expressly found in Section 3 of the Bill of Rights, other facets of privacy are found in other provisions of the Bill of Rights. In fact, there are even zones of privacy recognized and protected in our laws. Like those in the Civil Code, like those in the Revised Penal Code, like those in the Special Penal Laws, and even in the Rules of Court on Privileged Communication. Okay, so mayroon yan ha. We adopted the Griswold versus Connecticut ruling that there is indeed a causal right to privacy. In what case? Morphy versus Mutok. M-O-R-F-E, yung Morphy. Morphy versus Mutok. 1968 case. Okay, now. So, meron yan, now. What about yung right to a balanced and healthful ecology in accordance with the rhythm and harmony of nature? That is not found in Article 3. That is found in Article 2, Section 16. That is a right, yet it is not found in the Bill of Rights. Does that mean that it is less important than any of the rights guaranteed in the Bill of Rights? Oy, anong sabi ng Supreme Court dyan? It does not mean that it is less important. Why? Because actually, the rights that you find in the Bill of Rights are the civil and political rights. This right under Section 16, Article 2, which the state seeks to promote and advance, this belongs to a different category of rights. For it concerns nothing less than self-preservation and self-perpetuation, the advancement of which may even be said to predate all governments, all constitutions. As a matter of fact, this basic right did not even be written in the Constitution according to the court, for it is assumed to exist from the inception of humankind. If ever it is now written in the Constitution, it is because of the well-founded fears of its framers that unless this right is mandated as state policy by the Constitution itself, then the day would not be too far when all else would be lost, not only for this generation, but also for generations yet to be born. Generations which stand to inherit nothing but parched earth, dead seas, incapable of sustaining life. And because of that, what concept? The concept of intergenerational responsibility, which the Supreme Court in that case of Oposa vs. Factoran considered as a class suit. Ingatan nyo sa remedial loan yan, ha? Why class suit? The parties are simply too numerous that it becomes impossible to bring them all before the court. Imagine an entire generation. How can you bring them all before the court, including generations yet to be born? The parties are simply too numerous that it becomes impossible to bring them all before the court. Concept of intergenerational responsibility. It is the responsibility of this generation to preserve and conserve our resources, both our human and natural resources, so that they will be enjoyed not only by this generation, but they will be enjoyed as well by generations yet to be born. Kaya nga, intergenerational responsibility. Okay, you have to view that in that context, ha? So you have there, preliminaries. Now, if you analyze, of the 22 sections of the Bill of Rights, tingnan nyo, yung structure niyan, tsaka yung contents niyan. Actually, the first 11 sections, they pertain to the rights of the people in general. The first 11 sections, they pertain to the rights of the people in general. But beginning with Section 12 up to the last, Section 22, the focus of the Bill of Rights has narrowed. It has now focused on the rights of an accused. Kaya Section 12, ano yan? Custodial investigation rights. Section 13, right to bail. Section 14, the rights of an accused during trial. 15, yung privilege of the writ of habeas corpus. 16, right to speedy disposition of cases. 17, the right against self-incrimination. 18, the provision against involuntary servitude except as a punishment for a crime. 19, the provision against the imposition of cruel, degrading, inhuman punishment. Hindi ba? 20, ano yan? Yan ang constitutional right ng mga balasubas. Mahilig mangutang, ayaw magbayad. Di ba? You may not be imprisoned for failure to pay a debt or a poll tax. Di ba? 21, ano yan? The right against double jeopardy. 22, the right against ex post facto law and bill of attainder. So the focus has narrowed on the rights of an accused. Pero yung first 11 sections, they are the rights of the people in general. Beginning with Section 1, the right to due process of law, the right to the equal protection of the laws. Section 2, the right against unreasonable searches and seizures. Section 3, the right to privacy of communication and correspondence. Section 4 is your freedom of expression. Section 5 is your freedom of religion. Section 6, tatlo yan. Right to liberty of abode, liberty of changing the same abode, right to travel. By the way, in American case law, yung right to travel, ang tawag dyan, freedom of locomotion. Movement, travel, that is in American case law. Yung right to travel, tawag nila dyan, that is freedom of locomotion, movement. Section 7 is the right of a people to information on matters of public concern. Obviously, again, that is a collective right. The right of a people to information on matters of public concern. Section 8 is freedom of association. Section 9 is a limitation on the power of eminent domain of a state. Section 10 is the non-impairment clause. Section 11 is access to courts and quasi-judicial bodies. Those are the rights of the people in general, the civil and political rights. That's how your Bill of Rights is structured. Hati talaga yan. The first 11 sections, rights of the people in general. The remaining 11, they pertain to the rights of an accused. Okay? So you have to view it in that context. Kailangan alam niyo yung structure niyan eh. Familiarity with the codal provisions. The way your Bill of Rights is structured and the contents. Okay? Now, I hope you let us correlate with your loan evidence. 4 sections of the Bill of Rights are governed by the exclusionary rule in evidence. What sections? Sections 2, 3, 12, 17. Ano yung Section 2? The right against unreasonable searches and seizures. Section 3, the right to privacy of communication correspondence. Section 12, custodial investigation rights. Section 17, the right against self-incrimination. These 4 sections of the Bill of Rights are governed by the exclusionary rule in evidence. Why? Because any evidence, any admission or confession obtained in violation of any of these 4 will not be admissible. Excluded by the Constitution. What kind of evidence is that? Hoy. If it is excluded by the Constitution, what kind of evidence? Incompetent. Hindi ba your loan evidence? The rule on the admissibility of evidence? For evidence to be admissible, it must be relevant, it must be material, it must be competent. The test of relevancy, materiality, competency. Now, competent evidence, how is it defined? Evidence is competent if it is not excluded by the law or the rules. In other words, if it is excluded, then it becomes incompetent. It becomes the fruit of the poisonous tree. Hindi ba? Incompetent evidence. That evidence may be very relevant, it may be very material, but not admissible. Incompetent. Excluded by the Constitution. Excluded by the Bill of Rights. Because look, why don't you look at Section 3? Second paragraph, Section 3. What does it say there? Any evidence obtained in violation of this or the preceding section, referring to what? The right against unreasonable searches and seizures. Ano yan? Shall be inadmissible for any purpose in any proceeding. It is excluded by the Constitution. It becomes incompetent evidence. It is the fruit of the poisonous tree. On the theory, of course, that a poisonous tree may never bear good fruit. Oy, hindi ba? Oy, correlate nyo sa loan evidence nyo yan. Now, why don't you look at Section 12, the 3rd paragraph? Ano nakalagay dyan? Ala, sige. Nasa Discovery Channel na naman tayo ngayon, ha? You are beginning to discover your Bill of Rights, ha? Ano nakalagay dyan? Any confession or admission. Anong kind of evidence is that? Confession, admission. Testimonial evidence. What are the kinds of evidence? Real or object evidence. Tapos, documentary evidence, testimonial evidence. Confession, admission is a testimonial evidence. any admission or confession obtained in violation of this, sino may hawak ng maliit na konstitusyon? Yung pamphlet. Wala. Very good. Kasi nakalagay dyan sa mali yun. Kasi nakalagay doon, or the preceding section. If you happen to be holding that constitution, you better correct that one. Instead of this, or the correct provision is, or section 17 hereof, referring to the right against self-incrimination, shall be inadmissible in evidence against him. So it becomes incompetent evidence. Such admission, such confession obtained in violation of Section 12, custodial investigation rights, Section 17, the right against self-incrimination, not admissible, incompetent evidence, excluded by the Constitution. Likewise, it becomes the fruit of the poisonous tree. So it is in those provisions that you will apply the so-called fruit of the poisonous tree doctrine, which you always encounter in many of your readings in constitutional law. Di ba? So, anong provisions yon? What provisions of the Bill of Rights are governed by the exclusionary rule in evidence? Sections 2, 3, 12, 17. Huwag niyong tayaan sa loto yan. Okay? Now, and mind you, whether you like it or not, itong 4 sections, paborito. Nakakita na ba kayo ng bar examination na hindi nagtanong sa Section 2, 3, 12, 17, lalo na yung 2, right against unreasonable search and seizures, 3, custodial investigation, 17, right against self-incrimination? The bar examination will never be complete unless the examiner will draw questions coming from this area. Not only in political law, but even in remedial law. Hindi ba? Kaya if you focus on these 4 sections, kung 10 points lang, kukuha kayo ng 10 points in political law, as well as in remedial law. Kailangan mo na lang 90. Hindi ba? Kaya nga, you have to focus on these 4 kasi paborito yung 4 na yan. The bar examination will never be complete unless the examiner draws questions coming from these 4 sections. So take that into consideration, as you prepare for the Bill of Rights. So that is your Bill of Rights. Hindi ba? Ang dali. Di ba? Uy! Very easy. Now, Section 1. That is your, this is the catch-all provision. What rights are involved there? Dalawa yan. The right to due process of law, the right to the equal protection of the laws. Okay? The catch-all provision. Sabi nga, pag naubusan na kayo ng argumento sa Bill of Rights, gamitin nyo na yung Section 1, lalo na yung right to due process of law. Diba? Ano yung counterpart niyan in your civil code? What article is that? Oy. Yes, abuse of rights, diba? Oh. Section 19. Lagi sinasabi niya, pag wala na kayong argumento sa civil law, gamitin nyo na yung Article 19. Your catch-all provision. Ang counterpart niyan sa constitutional law, yung Section 1. The due process, the right to due process of law and the right to the equal protection of the laws. The catch-all provision. Now, in general, when do you invoke the due process clause? And when do you invoke the equal protection clause? In general, look at it in this context. If what is involved is an unreasonable act of government, unreasonable, whimsical, capricious, oppressive, confiscatory, you want to challenge that, you want to question that, anong i-invokein mo? The due process clause. No person may be deprived of life, liberty, or property without due process of law. Okay? Pero kung pinag-uusapan na, a discriminatory act of government. Nag-segregate na ng particular group, subjected that group to the different treatment. So, discriminatory act na yan. If you want to challenge that, that is the time for you to invoke the Equal Protection Clause. The Equal Protection Clause is a guarantee against any kind of discrimination on the part of the government and the agents of the government. So that is in general. Be guided by that. Kaya kung halimbawa, nakita mo, the act of government appears to be unreasonable, whimsical, capricious, oppressive, confiscatory, apektado ka nun. You want to question that? You invoke your right to due process. You may not be deprived of life, liberty, or property without due process of law. Pero kung nakita mo yung act is discriminatory and you are affected by that act, you want to question that. Kasi apektado ka. Nasaktan ka o masasaktan ka. Oh. You want to question that? Anong invoke mo? Equal Protection Clause. You may not be denied the equal protection of the laws. So, as broad as that, that is the broad formula. Isipin lang nyo yan, pag yung concept na yan, clear in your mind, makaka-argue kayo. You can always argue. Okay? Now, let us focus on due process. Now, pag pinag-usapan naman due process, they are of two kinds. Ano yon? Substantive due process and procedural. In Corona versus United Harbor Pilot Association of the Philippines, according to the Supreme Court, when one speaks of due process of law, a distinction must be made between matters of procedure and matters of substance. So, a distinction must be made between matters of procedure and matters of substance. So, you have to distinguish between procedural due process and substantive due process. In essence, procedural due process refers to the method or manner by which the law is enforced. That is procedural due process. Whereas substantive due process requires that the law itself, not merely the procedures by which the law would be enforced, is fair, reasonable, and just. That's how you distinguish substantive due process from procedural due process. So I repeat, in essence, procedural due process requires that the law refers to the method or manner by which the law would be enforced, while substantive due process requires that the law itself is fair, reasonable, and just, not merely the procedures by which the law would be enforced. To illustrate, let us assume hypothetically, in view of the worsening traffic situation, Congress enacted a law making it a criminal offense and penalizing it with the penalty of reclusion perpetua any person caught jaywalking. Jaywalking, penalty mo, reclusion perpetua. So as you can see, the law itself appears to be very unfair, unjust. Hindi ba? So what is involved there? A substantive due process. Can you imagine that one? Considering the nature of the offense, jaywalking, the penalty is deprivation of liberty the rest of your life. Obviously, the law is unfair, unjust. You are deprived of life, liberty, property, life, liberty, or liberty without due process of law. Hindi ba? So obviously, what is involved there is violation of not only procedural due process, but rather substantive due process. It strikes deep into the very heart of due process. Another example, concrete case, Tanyada versus Tuvera. Do you still remember? The secret decrees promulgated by then President Marcos. Ano sabi ng Supreme Court in Tanyada versus Tuvera? They should first be published. You have to comply with the requirements of Article 2 of the Civil Code. That's why even if it is expressly provided in the law that this shall take effect immediately, but you cannot dispense with the requirement of publication under Article 2. Ano ba nakalagay sa Article 2? Laws shall take effect 15 days after the completion of their publication in the Official Gazette, or as now amended by Executive Order Number 200, a newspaper of general circulation, unless otherwise provided. Hindi ba? O ano sabi ng Supreme Court? Tanyada versus Tuvera. Even if the law says that it shall take effect immediately, you cannot dispense with the requirement of publication under Article 2. Why? Imagine holding you liable for committing a law that was never published, that will strike deep into the very essence of due process. You are deprived of life, liberty, or property without due process of law. Holding you liable for violating a law which was never published, which never saw the light. That will be the height of injustice. Hindi ba? It strikes deep into the very essence of due process. So obviously what is involved there is, if you do not publish it and then you will hold a person liable for violating that law that you never published, you are robbing him of his life or liberty or property without due process of law. That strikes deep into the very essence of due process. Remember, substantive due process requires that the law itself must be fair, reasonable, just, not merely the procedures by which the law would be enforced. Hindi ba? That's why in Tanyada versus Tuvera, sabi ng Supreme Court, if the law was never published, Article 3 will not find any application. What is Article 3? Ignorantia leies non excusat. No, ignorance of the law excuses no one. Article 3, for that to apply, presupposes that the law has been published. Because once the law has been published, you can no longer feign ignorance of the existence of that law or of the contents of that law. You are supposed to know the law. But it presupposes that the law has been published. If the law had not been published, Article 3 will never find applicability. Holding a person liable for violating a law which never saw the light, that will be the height of unfairness, that will be the height of injustice. Obviously, what is involved there is violation of not merely procedural due process, but substantive due process. You are deprived of life, liberty, property without due process of law. You get the point? Uy, ala, sige. Sige kayo dyan, ha? Oh. So, tandaan nyo, ha? Substantive due process requires that the law itself is fair, reasonable, and just, not merely the procedures by which the law would be enforced. Whereas procedural due process refers to the method or manner by which the law is enforced. The essence of which is, what is the essence of procedural due process? Notice and hearing, or the opportunity to be heard. That is the essence of procedural due process. Notice and hearing, or opportunity to be heard. Di ba? Pero actually, if you'll analyze, alin sa dalawa nag-evolve first? Procedural or substantive? Alin sa dalawa? Nag-evolve muna. Hoy! Procedural. Di ba? Even in the Bible, di ba? It had its origin in the Bible, yung procedural due process. Hindi ba? When Eve partook of the fruit of the forbidden tree. Di ba? Alam na ni Lord yun. But was she immediately condemned? No. She was asked, did you eat of the fruit of the forbidden tree? Di ba? Was she immediately condemned? No. She was given an opportunity to be heard. Hindi ba? That was procedural due process. It was the Lord Himself who taught us procedural due process, the essence of which is opportunity to be heard. Kaya lang ang problema kay Eve, as you know very well, nagturo kagad. Sabi niya, di ba? It was the serpent, one of the commandments, the 11th, o 12th ba yun? Because 11th commandment is deny. Hindi ba the 10 commandments, 10 yan, may pang 11th yan eh. 11th, deny. 12, if you are forced to admit, implicate others, damay ka na. Puro dinamay niya kagad, tinuro niya kagad yung, hala, uy, ayaw, hindi na ma-accept to. Nandamay kagad, tinuro niya serpent, di ba? Oh, yan. Likewise, in the Bible, when Cain slew his brother Abel because of jealousy, ano yan? Alam na kagad ni Lord na pinatay niya yung kapatid niya. Was he immediately condemned? He was not. He was asked, Cain, where is your brother Abel? Di ba? O yan sagot ni Cain, suplado. Suplado pa eh. Arrogant pa siya eh. Sabi niya kay Lord, am I my brother's keeper? Di ba? Pero yung kagad, it was the Lord Himself in the Bible who taught us due process, procedural due process, the essence of which is opportunity to be heard. Di ba? So there you are. Very interesting. Now, when we talk of procedural due process, remember, the kind of due process as practiced in courts, I'm referring to the regular courts, is different from the kind of due process as observed in administrative proceedings. Di ba? Kasi, usually, due process as observed in courts, more strict yan. Samantalang administrative proceedings, liberal lang yan. In the first place, the kind of evidence required. It's a low kind of evidence. Substantial evidence. Hindi ba? And what is substantial evidence? Such relevant evidence which to a reasonable mind will be adequate to sustain a contention. Where do you find that? What ruling? Ang Tibay versus Court of Industrial Relations, the classic 7 cardinal or primary rights in an administrative proceeding. Those are the requirements of due process in an administrative proceeding. I hope you still remember the 7 cardinal or primary rights in an administrative proceedings. Yung pang-apat dyan, the evidence must be substantial. Diyan kinuha yung sa loan evidence nyo eh. That in an administrative proceeding, the evidence must be substantial. Kinuha yan doon sa ang Tibay versus Court of Industrial Relations. The fourth of the 7 cardinal or primary rights in an administrative proceedings. The fourth is the evidence must be substantial. Tapos define what is substantial evidence. It says there, such relevant evidence which to a reasonable mind will be adequate to sustain a contention. Di ba? Those are the requirements of due process in administrative proceedings. Hindi ba? Now, many of these labor cases that you're taking up in your labor law, ano yan? Procedural due process, administrative. Civil service cases, administrative. Hindi ba? Proceedings before quasi-judicial bodies, administrative proceedings yan eh. Iba yung proceedings sa RTC, sa MTC, sa Court of Appeals, Sandigan Bayan, Supreme Court. So I hope you still remember. You go over ang Tibay versus Court of Industrial Relations. There you will find the requirements of due process in an administrative proceeding. 7 cardinal or primary rights in an administrative proceeding. Go over those. Okay? So there you are. Now, development in this area on due process. Let us now tackle the first of the Mark Jimenez cases. Ang involved yan talaga, procedural due process. Is Mark Jimenez entitled to those documents he was requesting so that he can prepare for his defense? Now, I remember that the Mark Jimenez cases has something to do with extradition, as we discussed earlier. Now, remember that we have an extradition treaty with the U.S., the RPUS extradition treaty. And remember that we have our extradition law. What law is that? PD 1069. The law that seeks to implement the various extradition treaties we entered into with other states. Okay? PD 1069. Now, this first of the Mark Jimenez cases, by the way, do you know him, Mark Jimenez? Hoy! Sino siya? Hulog ng langit. No. Otherwise known as Mario Crespo. Siya rin yun doon sa Crespo versus Mogol. Yung Crespo doon, siya yon. Si Mario Crespo. You took that up in your remedial law. Hindi ba? Mark Jimenez is Mario Crespo. That's why you have to be very thankful to him. Because of him, our jurisprudence had been greatly enriched. So, remember that Mark Jimenez used to stay in the United States. Later on, he returned to the Philippines. Now, nalaman ngayon ng American government that Mark Jimenez was back in the Philippines. So what the American government did was to request the Philippine government, pursuant to the provisions of the RPUS Extradition Treaty, to have Mark Jimenez arrested here and extradited to the U.S. to face trial for his alleged criminal offenses there. Yung pala, may mga pending cases against him in the U.S. Okay. The request was coursed through the Department of Foreign Affairs, and the Department of Foreign Affairs, pursuant to PD 1069, our extradition law, transmitted the request to the Department of Justice for initial evaluation. Take note of the stage of the proceeding here. Initial evaluation stage at the Department of Justice. Nalaman ngayon ni Mark Jimenez na mayroon ng request for his extradition from the American government. So what he did, he requested the Department of Justice to give him copies first of the request for his extradition from the American government, and then the supporting evidences and documents, so that allegedly he can prepare for his defense. Of course, you know very well, ayaw magbigay ng Department of Justice. So eventually, Mark Jimenez elevated the issue before the Supreme Court. The question becomes one of due process. Sabi ni Mark Jimenez, how can I prepare for my defense if he'll be denied copies of those documents which I were requesting? He invoked his right to due process. Okay? Now remember, in a decision rendered on January 18, 2000, take note of that, the Supreme Court, by a vote of 9 as against 6, ruled in favor of Mark Jimenez. Wag mo na magsusulat yan. Iiyak naman kayo dyan mamaya. Ha? Sige, sulat na sulat dyan. Ha? I repeat, in a decision rendered on January 18, 2000, the Supreme Court, by a vote of 9 as against 6, ruled in favor of Mark Jimenez. Indeed, according to the Supreme Court, there was denial of due process. How can he prepare for his defense if he will not be given copies of those documents he was requesting. Now, this you have to understand. What was the basic premise of the January 18, 2000 ruling? The basic premise was this, that an extradition proceeding is similar to a criminal proceeding. That was the basic premise. That an extradition proceeding is similar to a criminal proceeding. And likewise, the initial evaluation stage in an extradition proceeding is also similar to a preliminary investigation in a criminal case. So that if you deny Mark Jimenez the copies of those documents he was requesting so that he can prepare for his defense, that will constitute denial of his right to due process. Okay? That you have to understand. But remember, even in that January 18, 2000 ruling, there were already dissenting opinions. In fact, one of the dissenting opinions, sabing ganon, this is no longer a question of due process. This is now a question of over due process. What happens now to our obligation to extradite pursuant to the RPUS extradition treaty, especially in view of pacta sunt servanda? Okay, do you get the point there? But that was the dissenting opinion. But then, as you know very well, the story did not end there. Because the Department of Justice appealed, or filed a motion for reconsideration. Now, 9 months later, or to be more precise, on October 17, 2000, the Supreme Court, in one of those rare instances, again by a vote of 9 as against 6, reconsidered. In other words, tatlong justices sumirko 360 degrees. And this is now the doctrine in that motion, in that resolution of the motion for reconsideration. Sabi ngayon ng Supreme Court, an extradition proceeding is actually sui generis, a clause by itself. It is not similar to a criminal proceeding which will call into operation all of the rights of an accused as guaranteed under the Bill of Rights. It is sui generis, a clause by itself. It is not similar to a criminal proceeding that will call into operation all of the rights of an accused as guaranteed under the Bill of Rights. So that is now very important. So how do you now distinguish an extradition proceeding from a criminal proceeding? You might be asked that one in your remedial law, in your criminal procedure, distinguish an extradition proceeding from a criminal proceeding. First, sabi ng Supreme Court, a criminal proceeding, as you know very well, involves the determination of the guilt or innocence of an accused. Hindi ba? It involves the determination of the guilt of or innocence of an accused. Extradition proceeding, does it involve the determination of the guilt or innocence of an accused? No, it does not. His guilt or innocence will be determined where? In the course of law of the requesting government. Hence, as a rule, according to the Supreme Court, constitutional rights that are only relevant to determine the guilt or innocence of an accused cannot be invoked by an extraditee, especially by one whose extradition papers are still undergoing evaluation. So there you are. That is a very important distinction. Do not forget that one. I repeat, a criminal proceeding involves the determination of the guilt or innocence of an accused. Extradition proceeding does not involve the determination of the guilt or innocence of an accused because his guilt or innocence will be determined in the courts of law of the requesting government. Hence, as a rule, constitutional rights that are only relevant to determine the guilt or innocence of an accused cannot be invoked by an extraditee, especially by one whose extradition papers are still undergoing evaluation. That's one major distinction. The others are as follows. Extradition proceeding under PD 1069, our extradition law, is summary. Summary in nature yan eh. Criminal proceeding, pwede bang summary? Hindi pwede. That will require a full-blown trial, adversarial. That is another important distinction. Another distinction with respect to the application of the rules of evidence. Criminal proceeding is strict adherence to the rules of evidence. Extradition proceeding, liberal interpretation rule yan. Another distinction, with respect to the quantum of proof required in a criminal case. What is the quantum of proof required for conviction? It's a very high kind of proof. Ano yun? Proof beyond reasonable doubt. Extradition proceeding, what is the quantum of evidence required? Ha? Oy, tika muna. Mali yan ha. You misread the case ha. What is the quantum of evidence required in extradition? It's a very low kind of evidence. Mere prima facie evidence. It's even lower than substantial evidence. Now, tika muna ha. You better we better clarify that point. Yung clear and convincing evidence as you read in Government of Hong Kong, that is the kind of evidence required in a petition for bail in extradition. But not in the proceeding itself. Sige kayo ha, basa kayo ng jurisprudence yan, hindi nyo nililiwanag yan ha. In an extradition proceeding, the kind of evidence required there is a very low kind of evidence. Mere prima facie evidence is even lower than substantial evidence required in an administrative proceeding. Later on, itatakal natin yun, ha, yung clear and convincing evidence na yan. Ha? But for the moment, I have to correct you there. Ha? Madadali kayo dyan. Finally, in a criminal proceeding, judgment becomes executory after having attained finality. Hindi ba? Judgment becomes executory after having attained finality. Extradition. Our courts may declare a person extraditable, but it will always be the president who will have the last say on the matter, whether to extradite him or not. Did you get that point? I repeat, criminal proceeding judgment becomes executory after having attained finality. Extradition proceeding, our courts may declare a person extraditable, but it will always be the president who will have the last say on the matter, whether to finally extradite him or not. So those are the important distinctions between an extradition proceeding and a criminal proceeding. That's why in this case, according to the Supreme Court, take note, as an extradition proceeding is not criminal in character, and the evaluation stage in an extradition proceeding is not similar to a preliminary investigation, the due process safeguards during preliminary investigation, they do not necessarily apply during the evaluation stage in an extradition proceeding. This we hold for the procedural due process required by a given set of circumstances must begin with a determination of the precise nature of the government function involved, as well as the private interest that has been affected by the governmental action. The concept of due process is flexible. For not all situations calling for procedural safeguards call for the same kind of procedure. So there you are. Secretary of Justice versus Honorable Ralph Lantion. The October 17, 2000 resolution, the motion for reconsideration, which is now the controlling doctrine. An extradition proceeding is actually sui generis, a class by itself. It is not similar to a criminal proceeding which will call into operation of the rights of an accused as guaranteed under the Bill of Rights. This is the controlling doctrine. The October 17, 2000 resolution, the motion for reconsideration, do not forget that one. Okay? Now let me clarify, let there be no misunderstanding here. In this resolution of the motion for reconsideration, the Supreme Court did not say that Mark Jimenez is not at all entitled to those documents he was requesting so that he can prepare for his defense. The court did not say that one. Ang sinabi lang ng Supreme Court, not at that early stage of the proceeding. Take note, what was the stage of the proceeding here? Initial evaluation stage at the Department of Justice. At that time, he is not yet arrested. Give him the documents he was requesting so that he can prepare for his defense. Sabi ng Supreme Court, what if he finds out from those documents na malakas yung ebidensya against him from the American government? Tatakas yan. Tatakas yan. Especially a man of his caliber who had the resources to plan and execute an escape. Remember, by the way, this is another very important postulate in extradition. What is that? An extraditee is always presumed to be a flight risk. That is the presumption. He is presumed to be a flight risk. Why? Simple. Sabi ng Supreme Court, dati nang tumakas yan. Kaya nga nagkaroon ng extradition proceeding eh. Kung hindi ba naman siya tumakas sa Amerika, magkakaroon ba ng extradition proceeding? It will not. There will be no extradition proceeding. He is presumed to be a flight risk. That is an important postulate again in extradition. Can you not apply the presumption of innocence in extradition? No, because as already clarified, an extradition proceeding is not similar to a criminal proceeding. The presumption of innocence is the right of an accused in a criminal proceeding. On the contrary, an extraditee is always presumed to be a flight risk. He is presumed to be a flight risk. Dati nang tumakas yan. Kaya nga nagkaroon ng extradition proceeding. Kung sa Amerika nga nakatakas siya, sabi ng Supreme Court, what more in the Philippines? Dito lahat tumatakas. Alam naman nyo yan. Hindi ba? So there you are. In other words, sabi ng Supreme Court, eventually he'll be given those documents. When? Once the petition for extradition is filed in court, but not at that early stage of the proceeding. Because you know why? Under PD 1069, our extradition law, the moment the petition for extradition is filed in the RTC, the judge shall immediately issue a warrant of arrest. Pag arestado na siya, he is now in the custody of the law, at yan, pwede siyang bigyan ng mga dokumentong hinihingi niya, sabi ng Supreme Court. But not at that early stage. Here, the court applied the so-called balancing of interest approach in resolving the question. I hope you still remember that balancing of interest approach. Under that balancing of interest test, usually there are two competing interests involved, which competing interests are equally desirable to society. The only question there is, given a set of circumstances, which of the two competing interests shall be upheld by the court? Dito, ginamit talaga ng Supreme Court yung balancing of interest approach. Since the proceeding here was still at what stage? Initial evaluation stage of the Department of Justice. He is not yet arrested at that stage. So what were the two competing interests involved here? First, the right to our interest in due process. The right to due process of invoked by Mark Jimenez. But then you have to consider another important state interest. Ano yun? Our obligation to extradite under the RPUS extradition treaty. So the court, by applying the balancing of interest approach, ruled in favor of the more compelling state interest at that stage. What interest is that? To prevent the escape of potential extraditees, which can be precipitated by premature information of the basis of the request for his extradition. That is the more compelling state interest. To prevent the escape of potential extraditees, which can be precipitated by premature information of the basis of the request for extradition. Remember, at that stage, he is not yet arrested. Give him copies of those documents. Paano kung makita niya malakas ang ebidensya? Tatakas yan. Especially a man of his caliber, he has the resources to plan and execute an escape. Since remember, in extradition, one important postulate, an extraditee is always presumed to be a flight risk. So, here, ginamit ng Supreme Court, I repeat, yung balancing of interest approach. By applying that balancing of interest approach, the court ruled in favor of the more compelling state interest at that stage. What compelling state interest? To prevent the escape of potential extraditees, which can be precipitated by premature information of the basis of the request for his extradition. So sabi ng Supreme Court, this is but a soft restraint on his right to due process at that stage. Remember that the court was very careful in its choice of words. This is but a soft restraint on his right to due process at that stage. There is no denial of due process for as long as fundamental fairness is assured a party. Now, medyo ingatan nyo, ha? You see, the Supreme Court was very careful in its choice of words. Sabi ng Supreme Court, this is but a soft restraint on his right to due process at that stage. Eventually, bibigyan siya noon. When? Once the petition for extradition is filed in the RTC. There is no denial of due process for as long as fundamental fairness is assured a party. So be mindful of this, ha? So let me clarify, ha? The October 17, 2000 resolution, the motion for reconsideration, which is the controlling doctrine. An extradition proceeding is sui generis, a class by itself. It is not similar to a criminal proceeding which will call into operation all of the rights of an accused as guaranteed under the Bill of Rights. So not at that early stage. Eventually, he will be given those documents when? Once the petition for extradition is filed in the RTC. Because under PD 1069, our extradition law, the moment the petition for extradition is filed in the RTC, the judge shall immediately issue a warrant of arrest. And once he is arrested, he is now in the custody of the law, he may now be given those documents. That's why, sabi ng Supreme Court, this is but a soft restraint on his right to due process at that stage. At that stage, there is no denial of due process for as long as fundamental fairness is assured a party. Get the point, ha? Do not forget those, ha? Now, total narito na tayo, baka para huwag tayo malagay sa alanganin, ha? Let us now consider the second. The second of the Mark Jimenez cases, Government of the USA versus Judge Porganan. Now, again, look at the stage of the proceeding here. After evaluation, the Department of Justice now filed a petition for extradition in the RTC of Manila. So in other words, the proceeding has advanced now. From initial evaluation stage at the Department of Justice, the proceeding has become judicial now. Remember, nagbabago yung nature ng proceeding. Judicial na ngayon, subject to the control of the court. Now, take note of that. Now, under question, because under Section 6 of PD 1069, our extradition law, once the petition for extradition is filed in court, the court will have to immediately issue a warrant of arrest. Now, one important issue, in fact, a novel issue, a case of first impression, in the second Mark Jimenez case, Government of the USA versus Judge Porganan, was this. Before a judge issues a warrant of arrest of an extraditee, kailangan ba yung prior notice and hearing? Is prior notice and hearing required? Now, in that case, the judge thought so. Sabi ng Supreme Court, that is not correct. That is not correct. That before a judge issues a warrant of arrest of an extraditee, he should be accorded prior notice and hearing. That is not correct. On two bases. What are these bases? The first is statutory. The second is constitutional. Let us begin with the first. Is prior notice and hearing required before a judge issues a warrant of arrest of an extraditee? Sabi ng Supreme Court, no. On the basis of PD 1069 itself, the extradition law. That is statutory. Sabi ng Supreme Court, look, it is significant to note that Section 6 of PD 1069, our extradition law, uses the word immediate, quote-unquote, immediate, to qualify the arrest of the accused. This qualification would be rendered nugatory by setting for hearing the issuance of the warrant of arrest. This qualification would be rendered nugatory by setting for hearing the issuance of the warrant of arrest. Hearing entails sending notices to the opposing parties, receiving facts and arguments from them, giving them time to prepare and present such facts and arguments. Arrest subsequent to a hearing can no longer be considered immediate. Arrest subsequent to a hearing can no longer be considered immediate. The law could not have intended the word immediate as a mere superfluity, but on the whole, as a means of impairing a sense of urgency and swiftness in the determination of whether a warrant of arrest should be issued. And then the court went further by using the phrase, if it appears, again in Section 6 of PD 1069. The law further conveys that accuracy is not as important as speed at such early stage. By using the phrase, if it appears, the law further conveys that accuracy is not as important as speed at such early stage. The trial court is not expected to make an exhaustive determination to ferret out the true and actual situation immediately upon the filing of the petition. From the knowledge and the material then available to it, the court is expected merely to get a good first impression, a prima facie finding sufficient to make a speedy initial determination as regards the arrest and detention of the accused. So there you are. On the basis of PD 1069 itself, is statutory basis. As you can see, prior notice and hearing is not a requirement before a judge issues a warrant of arrest of an ex-Atty. Now, second basis, constitutional. Under Section 2 of Article 3, is prior notice and hearing required before a judge issues a warrant of arrest of an accused? Why don't you go back to Section 2 of Article 3? Ano ba yung requirements for issuance of a warrant of arrest? Number one, it says there must be probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses may produce, particularly describing the person to be arrested. Mayroon bang binabanggit dyan na prior notice and hearing? Wala. On the contrary, it says there, after examination under oath or affirmation of whom? Of the accused? No. Of the complainant and the witnesses may produce. Because indeed, you can just imagine, halimbawa, yung kaso ng tao, murder, or rape with homicide, or kidnapping. Tapos, bago mag-issue ng warrant of arrest yung judge, sasabihin ng judge, oy, iho, halika, mag-hearing muna tayo kung kailangan kong mag-issue ng warrant for arrest. Tell me, sinong ma-arresto mo dyan? That was never a requirement. Notice or hearing was never a requirement before a judge issues a warrant of arrest under Section 2 of the Bill of Rights. That's why in this case, sabi ng Supreme Court, even Section 2 of Article 3 of the Constitution does not require a notice or a hearing before the issuance of a warrant of arrest. To determine probable cause for the issuance of warrants of arrest, the Constitution itself requires only the examination under oath or affirmation of complainants, not of accused, and the witnesses may produce. There is no requirement to notify and hear the accused before the issuance of warrants of arrest. In Webb versus De Leon, the court categorically stated that the judge was not supposed to conduct a hearing before issuing a warrant of arrest. So there you are. An issue of first impression. Government of the USA versus Judge Porganan. Notice or hearing, prior notice or hearing is not required before a judge issues a warrant of arrest of an ex-Atty. On two bases. What bases are those? First is statutory, Section 6 of PD 1069 itself. Second, constitutional, Section 2 of the Bill of Rights itself. You've got to learn how to argue here. So there you are. That was the first issue of novel impression in that second Mark Jimenez case. Government of the USA versus Judge Porganan. Now, another issue. Assuming that he is now arrested. Assuming that he is now arrested. So he is now in the custody of the law. Now, during the pendency of an extradition proceeding in the RTC, should he be allowed to post bail? Ayan na. The second novel issue in that case of government of the USA versus Judge Porganan, I repeat, during the pendency of an extradition proceeding, should he be allowed to post bail? What did the court say in that case? No. Why no? Sabi ng Supreme Court, as suggested by the use of the word conviction, why don't you go back to Section 13 of the Bill of Rights? Come on. Discovery Channel. Ano nakalagay dyan? All persons except those charged with offenses punishable by reclusion perpetua when evidence of guilt is strong shall be for conviction. The word used is conviction. As suggested by the use of the word conviction, the constitutional provision on bail, as well as Section 4 of Rule 114 of the Rules of Court on Bail, applies only when a person has been arrested and detained for violation of Philippine criminal laws. It does not apply to extradition proceedings because extradition courts do not render judgments of conviction or acquittal. Moreover, the constitutional right to bail flows from the presumption of innocence in favor of every accused in a criminal case. It follows that the constitutional provision on bail will not apply to a case like extradition where the presumption of innocence is not an issue. So there you are. In other words, following this ruling, the no bail rule applies in extradition. Following this ruling, Government of the USA versus Judge Porganan. So anong sabi ng Supreme Court? In holding that the no bail rule applies in extradition, as suggested by the use of the word conviction, quote-unquote, in Section 13 of the Bill of Rights, the constitutional provision on bail, as well as Section 4 of Rule 114 of the Rules of Court on Bail, applies only when a person has been arrested and detained for violation of Philippine criminal laws. It does not apply to extradition proceedings because extradition courts do not render judgments of conviction or acquittal. Moreover, the constitutional right to bail flows from the presumption of innocence in favor of every accused in a criminal case. It follows, therefore, that the constitutional provision on bail will not apply to a case like extradition, where the presumption of innocence is not an issue. So, following this ruling, the no bail rule applies in extradition. However, sabi ng Supreme Court, by way of an exception, he may be allowed to post bail for as long as two conditions are satisfied. What conditions are those? First, that once granted bail, he will not be a flight risk or a danger to the community. Second, that there exist special humanitarian and compelling circumstances that will justify the grant of bail to him. So what are those two conditions where he may be allowed to post bail? First, that once granted bail, he will not be a flight risk or a danger to the community. And there exists, number two, there exists special humanitarian and compelling circumstances that will justify the grant of bail to him. And since this is merely an exception, who has the burden of proving these two requirements? Who has the burden of proving these two requirements? The applicant, the extraditee. By what kind of evidence? Clear and convincing evidence. Okay? That was Government of the USA versus Judge Porganan. The second issue there. That was an en banc ruling, September 24, 2002. So, guided by that, the no bail rule applies in extradition. However, by way of an exception, he may be allowed to post bail provided that the two conditions are satisfied. What are those two conditions? First, that once granted bail, he will not be a flight risk or a danger to the community. Second, that there exist special, humanitarian, and compelling circumstances that will justify the grant of bail to him. And since this is merely an exception, who has the burden of proving these two requirements? The applicant, the ex-Atty. By what kind of evidence? By clear and convincing evidence. Okay, Government of the USA versus Judge Porganan, September 24, 2002, and Bank. Now, 5 years later, or on April 19, 2007, the court, an en banc ruling, in this case of Government of Hong Kong Special Administrative Region versus Judge Olalia, re-examine the Porganan ruling. Ang haba na naman ang sinulat yan. Ang sisipag kasi magsusulat ito. The Porganan ruling, which says that the no bail rule applies in extradition, had been re-examined in this case of Government of Hong Kong Special Administrative Region versus Judge Olalia, an en banc ruling April 19, 2007. So that now, hindi na yung no bail rule applies. He may be allowed to post bail now. Why? Ayan, pumasok na yung international law. Sabi ng Supreme Court, this court cannot ignore the following trends in international law. One, the growing importance of the individual person in public international law, who in the 20th century has gradually attained global recognition. Two, the higher the value now being given to human rights in the international sphere. Three, the corresponding duty of the countries to observe these human rights in fulfilling their treaty obligation. Fourth, the duty of this court to balance the rights of the individual under our fundamental law on the one hand, and the law on extradition on the other. The modern trend in public international law is the primacy placed on the worth of the individual person and the sanctity of human rights. Slowly, the recognition that the individual person may properly be a subject of international law is now taking root. So there you are, etc., etc. These significant events show that the individual person is now a valid subject of international law. Since what is involved in extradition here, whether he should be allowed to post bail is deprivation of liberty. Now, one of the important human rights, remember, is the right to liberty. In view of the significant events, then the Porganan ruling, which says that the no bail rule applies in extradition, should be re-examined. And re-examining that ruling, sabi ng Supreme Court, he should now be made to post bail. In other words, hindi na yung no bail rule applies. He should be allowed to post bail in view of these developments. Besides, sabi ng Supreme Court, remember in Porganan we held that the right to bail applies only to one arrested and detained for violation of Philippine criminal laws. That was the holding in Porganan. The right to bail applies only to one who has been arrested and detained for violation of Philippine criminal laws. But why is it that we have earlier decisions allowing an accused in a deportation proceeding to post bail? Remember that a deportation proceeding is not a criminal proceeding also. Yet, we have allowed an accused in a deportation case to post bail. With more reason, in extradition, since what is involved is such a precious right as the right to liberty, then we have to re-examine the Porganan ruling. So we have to allow him to post bail. However, for him to be allowed to post bail, still the two conditions should be satisfied. What conditions? First, that once granted bail, he will not be a flight risk or a danger to the community. Second, that there exist special humanitarian and compelling circumstances that will justify the grant of bail to him. And the burden of proving these two requirements still lies on his part by what kind of evidence? A clear and convincing evidence. Now, this time, the court adopted a new standard of evidence. Clear and convincing evidence. So, sabi ng Supreme Court, what is a clear and convincing evidence? It is an evidence lower than proof and reasonable doubt required in a criminal case, but higher than preponderance of evidence required in a civil case. So obviously, sa gitna yan, a new standard of evidence. Kaya in your loan evidence, baka ma-encounter niyan, ha? What is that new standard of evidence? Clear and convincing evidence. An evidence which is lower than proof beyond reasonable doubt required in a criminal case, but higher than preponderance of evidence required in a civil case. So, this is now a new standard of evidence. So, the Porganan ruling, which says that the no bail rule applies in extradition, had already been re-examined. Instead, he should be allowed to post bail. However, for him to be allowed to post bail, the two conditions laid down in Porganan should remain the same. Siya pa rin ang magpo-prove noon. Kaya lang, by what kind of evidence? It's now a new kind of evidence, a very high kind of evidence, clear and convincing evidence. An evidence which is lower than proof and reasonable doubt required in a criminal case, but higher than preponderance of evidence required in a civil case. Government of Hong Kong Special Administrative Region versus Judge Olalia, April 19, 2007, and bang. Okay? Hoy. So, ito na ngayon. Hindi na yung no bail rule applies in extradition. To that extent, the Porganan ruling had to be vacated, was re-examined in fact. Kaya lang, be careful again, ha? Do not indulge in sweeping generalizations. Baka naman sabihin nyo that the Porganan ruling had already been abandoned. Only one aspect of the Porganan ruling was re-examined. Ano yon? With respect to the right to bail in extradition. What is the other aspect of Porganan? Before a judge issues a warrant of arrest of an ex-Atty, is prior notice or hearing required? No. That was unaffected by the Olalia ruling. That aspect of the Porganan ruling is still valid. Clearly unaffected by the Olalia ruling. So, before a judge issues a warrant of arrest of an ex-Atty, prior notice and hearing or hearing is not required. On two bases. What basis? Statutory, Section 6 of PD 1069, and constitutional, Section 2 of the Bill of Rights. Again, let me caution you, do not indulge in sweeping generalizations. Baka sabihin nyo, the whole of Porganan had been re-examined. It's not correct. Only one aspect of the Porganan ruling with respect to the right to bail. Okay? You have to view it in that context. So these are the Mark Jimenez cases and the developments, a very significant development in this area. We tackled all of them. Be careful. The first, government of Secretary of Justice versus Honorable Ralph Lantion. The controlling doctrine is the October 17, 2000 resolution of the motion for reconsideration, which says that an extradition proceeding actually is sui generis, a class by itself. It is not similar to a criminal proceeding which will call into operation all of the rights of an accused as guaranteed under the Bill of Rights. And because of that, it becomes important for you to know that the the distinctions between a criminal proceeding and an extradition proceeding. You might encounter that in your remedial law. But then you have to be very careful. In that ruling, the court did not say that Mark Jimenez is not at all entitled to those documents he was requesting. Ang sinabi lang, not at that early stage of the proceeding. Here, the court applied the balancing of interest approach. Considering that the proceeding was still at its initial evaluation stage sa Department of Justice, sabi ng Supreme Court, not at that early stage. Because here the court ruled in favor of the more compelling state interest. What is that more compelling state interest? To prevent the escape of potential extradites which can be precipitated by premature information of the basis of the request for his extradition. Especially since, remember, one important postulate in extradition is that an extradite is presumed to be a flight risk. This is but a soft restraint on his right to due process at that stage. A soft restraint on his right to due process at that stage. Eventually, he will be given those documents. There is no denial of due process for as long as fundamental fairness is assured the party. But as to the other, after that you have government of Hong Kong, or rather, government of the USA versus Judge Porganan, the two novel issues there. Kaya lang yung second second issue, that the novel rule applies in extradition, that had already been re-examined. In this case of government of Hong Kong versus Judge Olalia. So that instead of the no bail rule, he should be allowed to post bail. But then here in re-examining the Porganan ruling on that issue, the court here considered the developments in international law. The modern trend in public international law is the primacy placed on the worth of the individual person and the sanctity of human rights. Slowly, the recognition that the individual person may properly be a subject of international law is now taking root. These significant events show that the individual person is now a valid subject of international law. You have to take that into consideration. That's why we focus on that also when we're discussing public international law, subjects of international law. Okay? Developments in those areas. Do not indulge in sweeping generalizations. Let me caution you. That's why you have to know the evolution and the development in jurisprudence. Okay? Be guided by that. Be analytical. So we'll continue tomorrow, We'll consider the others. We have until Saturday. Now, by the way, let me reiterate, Saturday afternoon, you better attend the lecture by Justice Vitog in civil law. An authority in that subject. His insight, his views could give you a better insight. Yan ang 14 niya. And then after that, you have my good friend, si Professor Rene Gorospe. He tends to compliment me and vice versa. I tend to compliment him also. We complement each other. Now, do not forget that movie, Black Hawk Down. Ano yun? Leave no man behind. You better complement, you better reinforce each other. Your common enemy, quote-unquote, is the examiner, a nameless, faceless individual, whoever he may be. Although we now have our suspects. But remember, he is presumed innocent until the contrary is proved. Take note of that, But siya yung common enemy nyo, hindi yung seatmate mo. Kaya nga, that was a very beautiful slogan there in Black Hawk Down. Kaya gustong-gusto ko yung pelikulang yun Because of that, leave no man behind. Okay? Thank you and good night.